What I want to do in this video is talk about the sources of the UK Constitution. In the last lesson we talked about how the UK Constitution is unwritten, is uncodified, okay, it's not all written down in one singular place. And we're going to explore this issue a little bit more in this lesson, because we're going to be talking about if it's not written down in one singular place, then whereabouts is it written? You know, how can we derive the sources of the Constitution? So, as an introduction, generally speaking, there we go. The UK Constitution has a number of different sources. The list is relatively non-exhaustive. You know, we could include other kinds of things in here, but generally speaking, the main sources of the UK Constitution are these main five. So we're going to talk about the common law. Okay, we're going to talk about parliamentary statute, so acts of parliament. Okay, we're going to talk about European Union law in a separate video, because as we know, we have the issue to talk about when we are discussing the legal implications of Brexit. So we'll park that one for the next lesson or a lesson after this. We're going to also touch briefly on constitutional conventions, but constitutional conventions are something that again there's a lot more legal nuance to the issue of constitutional conventions. So we're going to talk about them again in another separate video in more detail, but we'll touch on them here. And then we can also talk about works of authority, authoritative works. So to start off, let's talk about the common law, the system of common law. And effectively, a way to define the common law is just the rules formulated by judges in cases that have made, they make a significant contribution to the development of the Constitution. So they make a significant contribution to the development, because the Constitution isn't a single, a single rigid document like, say, the United States. We have a Constitution that's a lot more free-flowing, a lot more fluid, okay? And the common law has been a very significant addition to the development of general principles of constitutional law. And it implies, when we give common law this sort of constitutional status, it implies that the UK courts have more than just a legal role. They have what we call a constitutional role. And in the case on the application of Spath Home Limited and the Secretary of State for the Environment, Transport and Regions in 2001, we see that Lord Nichols described this constitutional role as, they said that in interpreting statutes, they must ascertain the intention of Parliament. And this is to be done on more of a de jure basis rather than a de facto basis, by taking an objective approach to the meaning of the words in the statute. Okay, let me just try and underline things properly. There we go. Oh, I'm not doing this very well. There we go. They want to take an objective approach to the meaning of the words, rather than talking about parliamentary actions, more like the sort of de facto reality actions. They want to talk about the legality objectively within the language that's used in a piece of statute. And as such, the question for the court will be whether it's reasonable for the statute to be interpreted in a particular way. So we're talking, this constitutional role relates to this idea of interpretation, interpreting legislation in a way that is reasonable for us to interpret a piece of statute. And I believe it was Lord Phillips, the former this former head of the UK Supreme Court, who made the claim that Parliament effectively churns out different pieces of legislation, and it's up to the court system, it's up to the Supreme Court to interpret those statutes to see what they actually mean. Okay, to see what the Parliament was intending to do when they were creating a piece of legislation. And when it comes to legislation, we need to talk about acts of Parliament as part of the Constitution, as a source of the Constitution. So theoretically, because Parliament is sovereign, it has the ultimate primary legislative authority. Okay, any act, technically by that standard, contributes to the Constitution. Okay, and this is the traditional view the traditional view of parliamentary sovereignty. There is more. There are some challenges to the traditional view. You've got things like European Union law, the issue of devolution, things like this. But for now, the traditional view that Parliament is sovereign to make and unmake any law technically means that any act of Parliament could be seen as one that's constitutional. However, in reality, legal scholars and the sort of jurisprudence around acts of Parliament have generally made this a delineation between what we would describe as normal statutes and ones that are of a constitutional nature. So, when we're talking in technicalities, we could say, maybe we could argue that the any act of Parliament contributes to the Constitution. However, in reality, we can understand that there are more, that there are some acts of Parliament that are, less constitutional. They have less of a constitutional impact, and then there are some that are of quite significant constitutional impact. And we can sort of draw a line and draw a distinction between the kinds of acts of Parliaments here. And when we talk about the case law on this, laws LJ defined in Thoburn, and Sunderland City Council, that constitutional statutes are ones which condition a legal relationship between the citizen and the state. Now, this is a very important quote. So, a legal relationship between the citizen and the state. As we talked about, a constitution, and by extension, constitutional law relates to the relationship, to the relationship between the people and the state. So between the people and the state. So there we go. I've written a lot here. I'm not normally people and the state. Now, what's important here is, this is one aspect of what we would describe as constitutional law. I talked about this in the very first lesson on constitutional law. We're talking about a relationship between people and state. So when you've got pieces of legislation that don't necessarily have a significant impact on the relationship between a citizen and a state, then the argument can be made that that is a statute that is of less constitutional significance. Okay. They also said that a statute can be constitutional in nature if they, quote, enlarge or diminish the fundamental scope of constitutional rights. So we talk about constitutional rights in a later lesson, but the idea, and again, this also relates to, the relationship between the people and the state. Between people and state. People and state. That symbol means and. I just like to use shorthand just to try and make it easier to read for everybody. On top of this, we've got these kind of two ways in which we can delineate between constitutional statutes and normal statutes. We can talk about the condition of the legal relationship. Okay, we've got the legal relationship between citizen and state, and then we've got, does the piece of statute enlarge or diminish the fundamental scope of constitutional rights? Now, they went on to list a number of statutes that would fit the definition of being a constitutional statute, that either condition a legal relationship between the state and the people, or enlarge or diminish the fundamental scope of constitutional rights, or both, effectively. So we've got a number of pieces of law that we could look at as examples of constitutional statutes. So you've got, of course, Magna Carta being incredibly important. Again, the Bill of Rights, Union of Scotland in 1706, Representation of the People's Act, and very important, all the acts of Parliament relating to representation of the people. So 1832, 1867, and 1884. More modern examples, when we're talking about the era of the Blair government, New Labour, we have the Human Rights Act, of course, relating to the enlargement of the fundamental scope of constitutional rights, and it also relates to the relationship between people and the state. When you do human rights law, you're going to be talking about an act, something that is brought against the state, okay, using the mechanism of the Human Rights Act, or the ECHR. You've also got things like legislation relating to devolution, so you've got things like the Scotland Act, you've got the Government of Wales Act, and you've also got relationships relating to international institutions, things like the European Union, the European Communities Act, and we could also talk about the UK Withdrawal Act. So the UK Withdrawal Act of 2020. So this is something that obviously they didn't list in their 2003 case, but we can also bring about, bring a number of statutes that have subsequently, since 2003, been passed that we would say have a constitutional nature. I'm not going to list any more because I want you to think about that on your own and try and work out, okay, what other kinds of pieces of legislation can we think about that are constitutional in nature, that fit the definition that's established in Thoburn and Sunderland City Council. And there are loads. I've given you one here, so you're not allowed to use Brexit. I've given you one here, but you can use a number of others. So moving on, we're going to, like I said, we're going to talk about European Union law in a separate video because the complexities of European Union law are something that I want to cover. I don't want to make this video too long, so I want to cover that separately. Let's talk about constitutional conventions. Constitutional conventions are very, very interesting. And they're also what I would describe constitutional conventions as quite tricky. There's a little bit more nuance to constitutional conventions. So A.V. Dicey defined a constitutional convention in his seminal work, in his authoritative work. Okay, so work of authority. Which is the study of the law of the Constitution, 1885. He said that they are as separate from law. Okay. A constitutional convention can be best described as the kind of general norms that are not legally binding, but over the years have become accepted practice. So this is just a general definition of what we mean when we talk about constitutional conventions. And from this general definition, we can derive a number of conclusions. So we could argue that A, based on this definition, conventions are therefore not enforceable like other laws. Okay, they are separate to law. They are something different. And B, because they are not laws, okay, and because they are not enforceable like laws, there's no judicial remedies or penalties for anyone who violates the convention. So, for example, if we take an example from, say, tort, if you have, someone brings a case of negligence against you, and that is proven to be, a valid case of negligence, then there are judicial remedies that can be levied against you to get to penalties to remedy the situation. However, if there's no way of enforcing constitutional conventions, if they're just generally practiced norms that don't really have any binding authority, then there's no way that a judge will ever be able to issue penalties or allow remedies for violations of any convention. Now, there are a great many numbers of constitutional conventions, and we're going to talk about them in a lot more detail as they come up throughout when we're talking about the relationship between Parliament and the Prime Minister, etc., etc. But we've got a couple here, so I want to start from the bottom. So the appointment of the Prime Minister by the Monarch. Now, the Constitutional Convention with respect to this is that the Monarch appoints the Prime Minister, and the Prime Minister is the leader of the largest party. Leader of the largest party. Now, this is just a convention. You could quite easily have a situation where a general election is held, one party wins, and the monarch decides not to appoint the Prime Minister who is the leader of that party. They appoint somebody else, not necessarily the leader of a different party, but just anybody in the Commons or the Lords. So now, whether or not whether the legal, the democratic implications of if that was to ever happen would be just huge, but this is generally just an example of a convention. The convention is that the monarch appoints the leader of the largest party as to be prime minister. There's another convention relating to the government's relationship with the House of Lords. This is the Salisbury Convention, and this is the convention that if a bill is part of the manifesto of the government, okay, of the leading party, then it's the general convention that it shouldn't be blocked or struck down by the House of Lords, because that would be seen as anti-democratic, because if it is in the manifesto of, so we're talking, for example, the Conservative Party right now, if they pass a bill in the House of Commons that is a manifesto pledge that was in their manifesto, then it's generally accepted that they have a mandate to be able to pass that bill, because it was in the manifesto and people voted for the party, hopefully voted for the party on the basis of their manifesto pledges. So it would be undemocratic for an unelected body like the House of Lords to vote down things that could be seen as the will of the people. So that's what the Salisbury Convention is. And then we've got the principle of collective responsibility. Now, the principle of collective responsibility relates to the government, internal government affairs, and it's generally the position that the cabinet and ministers within government ought to be show a united front on a particular issue. So let's take a very brazen example. If we have a cabinet meeting and one of the ministers vehemently disagrees with the rest of them about the policy positions that the policy direction that ought to be pursued, then they've got two options, okay, because they've been outvoted. If they want to criticise the government and come out to the public and say, hey, this is what I thought, and I disagree, then they ought to resign. That's the principle of collective responsibility. If they're going to stay on as minister of state, then they have to collectively hold the responsibility and show a united front. So this is the principle of collective responsibility. And just like when we're talking about this, we're going to talk about these in a little bit more detail. When we talk about the government and the executive branch, we'll be talking about responsibility in a lot more detail. When we talk about Parliament, we'll talk about the Salisbury Convention. And when we talk about the monarchy and the royal prerogative, we'll talk about that. However, there are some legal implications to the idea of constitutional conventions. There are some interesting questions to whether or not constitutional conventions really are enforceable, whether or not constitutional conventions could ever become binding in law. These are the kind of questions that we're going to look at in a lot more detail in the next lesson when we try and unpack the nuanced questions around the practice of constitutional conventions.